Good morning and welcome to today's webinar, The Essentials of Estate Planning and Elder Law, presented by Elville and Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and I'll be moderating today's event. This webinar is offered in partnership with Visiting Angels, a longtime supporter of Elville and Associates educational programs. To learn more about Visiting Angels, its services, educational programs, and calendar of events, please visit www.visitingangels.com or contact Ms. Stephanie Lawler, Home Care Consultant, at stephaniel@mdvisitingangels.com. So again, welcome to everyone. If you're new to our presentations or returning to see us again, currently you're, as the attendee, are in listen-only mode. However, if and when you have questions, as always, please note them in the questions panel on the right-hand portion of your screen, and we'll take time throughout to address them. Your questions really help the presentation and add value. They help others learn, so please don't be shy in posing your questions at any time. You received the presentation yesterday by email for me to take notes on it if you wish. If for some reason you did not receive the presentation yesterday, it is currently in the section marked Handouts to download at this time. For CFPs, CPAs, and various other professionals on today's webinar, welcome. You may receive 1.5 continuing education hours for attending. So, per attendance records requirements on my end, please email me your board ID. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Lastly, everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please take just a couple minutes to fill out the simple survey to give us your feedback about today's presentation. And as always, we read and value every comment. It's also an ideal time to request a consultation with Steve for any planning needs that your family and you may have. And here at Elville and Associates, we look forward to being a resource to you now and in the future. So briefly, as we have a lot to cover, I'd like to give you an overview about our firm and share a little bit about Steve. And I think you should be able to see my screen here. I'm gonna pull this up real quick. So Elville and Associates, we were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We have several practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 7 attorneys, 12 staff members, and 5 locations. Stephen and I are coming from you live at the Columbia Gateway location today. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. We do offer a lot of education here at Elville & Associates, and we do things a little bit differently than many other law firms out there. We do that through our planning processes with our clients. We offer over 100 educational webinars and workshops in the communities that we serve each year, and also by way of our accredited client care program. We are one of only 2 firms in Maryland to have an accredited CCP, as we call it here, accredited by the Client Care Academy in Boston. We also work with the ideals of client education, collaboration, and compassion in mind with every client, every time, every day. A little bit about Steve. His work as an attorney for the past 20 plus years, 22 to be exact, has been centered in elder law, special needs planning, and estate planning. A member of many different membership organizations that are national, including the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He works to bring peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. A very seasoned speaker, if you haven't heard Steve talk before, presenting at many webinars, workshops for businesses and their employees, conferences, and continuing education events. Recently named to the Maryland Super Lawyers list for a 7th time in 2022 and a 6th consecutive year. So congratulations to Steve. and also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I am privileged to be the executive director of. So if you'd like to learn more about the Elville Center and how we work to make a musical difference in the lives of children each day, please feel free to reach out to me, and I'll be very happy to share our story with you. So with all that said, we're going to jump into the presentation, but we have a poll to do first. We want to learn about you and see what's brought you here today. And the poll simply is, if I can find it, what brings you to today's webinar? We'd like to know about our audience so Steve can tailor his discussion to you, our attendees. So I'm going to launch this poll, and the poll is open. And the choices are: 1, I am new to estate planning and need to get started. 2, I have a plan in place but is outdated and needs updating, which we see a lot here. 3, I feel my plan is on solid ground, but education is great. It is great. Lastly, I'm an advisor here to learn to better serve my clients. So welcome to our clients. Welcome to our friends from the community here joining us today, and our financial advisors that are here, and we value our relationship with them very much. Make the choice that best suits you, and we'll see what we have, who we have joining us today. Okay, so we have 40% saying I'm new to estate planning and need to get started. Nobody says they have a plan in place but is outdated and needs updating. A little bit unusual. 25% say I feel my plan is on solid ground but education is great. And 38% say I'm an advisor here to learn to better serve my clients. So welcome everybody. Steve, I'm going to go ahead and give you the controls.
Thank you, Jeff. I will take control, and I'm going to see if I can get my screen the way it should be. How about that, Jeff? Do you see my screen?
Looks good. Yep.
All right, very good. Thank you, Jeff. And good morning, everyone, and happy Friday. And I want to thank everyone for being here, spending your very valuable time with us on a Friday morning right before Memorial Day weekend. It's my privilege to be here with you. I'm Steve Elville. I want to thank Jeff Stauffer, my wonderful moderator here and my good friend and longtime colleague, without whom I could not do what I do here at Elville & Associates. And I want to thank everyone here at Elville & Associates for making everything happen that has allowed me to be here today with you. It's a very strange Friday morning in the sense that we're all anticipating the weekend, and yet the weather is not that great here in Columbia anyway. You'll notice I'm wearing my tie with flowers, so I'm very optimistic about good weather. And Jeff tells me, he assures me that the weather is going to get better. So Jeff, I hope you're right on that, and hope you have a wonderful weekend ahead. But we're here to talk about estate planning, and I'm going to impart a lot of fundamental information to you today. I like to think of this Estate Planning Essentials and Elder Law class as really the quintessential master class that we offer here at Elville & Associates. So there's a very uncertain world out there today. I know many of you have a lot of concerns about the state of the world, the state of our country, the state of the economy, all of the things that we always are dealing with in our busy lives today. And we're going to take all that into consideration as part of the discussion. What I'm going to lead you through today is the ideal way of doing estate planning, the ideal way of thinking about elder law, the ideal way of thinking about these broader issues. But some of you are concerned about having a plan now. Some of you are concerned about getting something in place. So we want you to know that we believe in education. We believe we're one of the only law firms in Maryland that actually provide the kind of education in the format that we provide it, and that we actually deliver on educational approaches to clients and couples and single people and their family members, their fiduciaries. But this educational process takes a little bit of time, and some of you are more concerned about getting something in place. more quickly than some of our processes, but we're going to take all of that in consideration because it is important to get planning in place, but it's also important to have an educational process. So we just want to be very clear about that up front. We know some of you are very concerned about your powers of attorney and advanced medical directives and wills and trusts and getting a plan in place. But in the background, we want to make sure that you are educated. So with that said, let's get right into the discussion. And thank you again for being here. So our goal today is really to talk about what estate planning is and what is a process for estate planning. Most estate planning is not done on a process or in a process. We're going to talk about why that's important. And a lot of estate plans don't end up working the way they should. And many of you have seen this in your own lives where you make a plan or you think that you've gotten something in place where you're going to go from point A to point B to point C, which is very much what we're doing in estate planning. But if we're not really cognizant of how we're going to keep those things in place in the future, that plan can fall apart. And an estate plan is no different. An estate plan can fail if we're not careful about how we follow up with it in the future. So that's a concept I want to impart today. We're going to talk about wills versus trusts. We're going to talk about probate versus non-probate. That is one of the biggest questions people have in America, and a matter of fact, all around the world. What is the difference between a will and a trust? What is the difference between probate and non-probate? We're going to talk about basic concepts of elder law, basic taxation concepts, and asset protection concepts. Many of you might be concerned about asset protection, protecting spouses, protecting children, grandchildren, nieces and nephews. And then we're going to talk about the estate planning process itself in the context of how do we get started. So understanding an estate planning process is very important because we have to begin with our goal. We always want to begin, and especially in estate planning, we want to begin with a goal in mind. But that goal is very important no matter what kind of planning, whether it's financial planning, tax planning, asset protection planning, special needs planning. Estate planning in general is no different. So you're going to have your own reasons for planning. So we're going to be talking about why you should plan and why we should be concerned about the estate plan actually working throughout our lifetime. So I want you to have a goal. I want you to have a purpose in the planning. As you're going to go through this material this morning, you're going to maybe have an epiphany, perhaps, about whether or not you actually have a goal. And it's okay if you don't really know what that goal is. We have 3 major conference rooms here at Elville and Associates at this particular location. I'm in the biggest one here, conference room number 1. And this whole conference room is geared, it's a very high-tech conference room. It's geared for visual illustrations and lots of room and lots of space and time to think. So we want you to have the idea of having a goal, but if you don't have one right now, I promise that through counseling and through having a place to think about it, you'll be able to develop your goal and a purpose. Some people want to provide certainty for their loved ones, and that's very understandable. A lot of people say, I want to make things easy for my beneficiaries, for my children, for my nieces and nephews. I want to make things easy. I want things to be smooth. I want to minimize the cost involved. Many people are focused on this. Some people, as I mentioned, are focused on asset protection. How do I protect my child or my grandchild who has issues or has special needs, or my child has spendthrift issues. They can't seem to handle money and so forth. Many people are focused on eliminating taxes. So this is a big focus in planning. We're living in a time right now where tax advantages are pretty much extraordinary in estate planning. We're hoping that always stays the same, but it may not. And of course, as I mentioned, you may have your own definition, your own reasons for planning. Now, we have this issue of the potential, the real potential for planning to not work the way it's supposed to. So the way to start dealing with this is right from the outset. We have to realize that if we look at an estate plan, If we accept the concept that an estate plan is a document like a will, or a document like a power of attorney or advanced medical directive or a trust, those physical documents, if we look at that and say, well, that's an estate plan, that's where we are already going on the wrong track. We want to pull back and we want to say, no, that set of documents, even though it looks good, it looks like an estate plan, it is basically an estate plan, it's representative of an estate plan. Those documents in and of themselves are not the real estate plan. The real estate plan is the process. It's the lifetime process. How do I know this? Well, let's talk about statistics. Statistics would tell us that only about 40 to 45% of people actually have an estate plan. That means of all the people in the United States, only about 45% actually have an estate plan. That means that 55 to 60 or maybe a little bit higher percent in some demographics like divorced individuals do not have an estate plan. Okay, so let's first of all get our minds around that. So that a minority of people actually have estate planning. Now, of those minority of people, meaning the 40 to 45%, most of those people don't keep up their estate planning. They do planning, and if you see this last bullet point here, they typically do not follow up after they've done an estate plan. Now, these are the people who do good. They're doing the good things, the right things. They are not following up for about 19 years at a time, 19 to 20 years. So if you have an estate plan and you don't revisit that estate plan for 20 years at a time, is there a high possibility that your estate plan will fail to work the way you wanted it to work? I think the answer is obviously yes, and that is the case. So we want to avoid this by realizing documents in and of themselves, a set of documents, no matter how good they look, do not represent a complete estate plan. Estate planning is a process. So what I just described is what I would call traditional estate planning. That's what is going on out there in the United States. We have attorneys, good attorneys, smart attorneys, who do not provide their clients with a process. It's more of a transaction, very short transaction. Here is some information to the lawyer, and the lawyer feeds back a set of documents. That is okay if I'm traveling to Europe next week and I need a will or I need a trust quickly. But if I'm really a person who wants my estate planning to work, I want it to work now, I want it to work 20 years from now, and I want it to work when I pass away for my beneficiaries, then I have to look at a process-driven plan. So we want to stay away, if we can, from the traditional notion that estate planning is really a transaction and it's a set of documents. And we want to really go to a process that, whether it's 3 steps like I'm outlining here, or whether it's a multi-step process that's even beyond 3 steps, it doesn't matter how many steps. What matters is that we understand that we don't want to focus on a set of documents. The people who do estate planning, what do they do with those documents? They probably put them in a drawer at home. They probably put them in a safe deposit box, probably put them in a safe somewhere, and then they don't revisit those for 20 years at a time. So just reiterating that that's not what we want to do. We want to instead look at estate planning as a 3-step process or a multi-step process. We want to look at it as a design and implementation phase. So, as I mentioned earlier, many of you may not even fully know or fully have decided what your designs are and your ideas and your plans and your purposes for your estate planning. But you have to give yourself room to think about that. So we meet, we go over these basic concepts, we work on the whiteboard, we work through your goals and values, and we design a plan, and you implement that plan. And then throughout your lifetime, you maintain that plan, just like you maintain your investments and your consultation with your financial advisor, if you have one, or through your tax advisor every year. Methodically throughout the years to come, you maintain and update your planning. And then the reward is that at our final administration, when we are no longer living, our plan will actually work the way where it's supposed to work. So an estate-driven plan a process-driven estate plan is what I meant to say, incorporates a multi-phase educational process where maintenance and updating of the plan is important, it's emphasized, and you have the path forward to be able to do that. Now let's talk about a very simple definition of estate planning. Estate planning is about what? Well, it could be about anything that you're really concerned about, but a very general definition is estate planning is about giving or disposing of your property at your death the way you want to the persons or organizations of your choice at the lowest possible cost. So if you are writing this down, I'm going to repeat that again. Estate planning is about disposing of your property the way you want to the persons or organizations of your choice at the lowest possible cost. That's one very general, very simple definition of estate planning. All right, I'm going to keep moving now. If you have questions, Jeff will interrupt me if he gets a question from you, or we will pause throughout the presentation. I'm now going to segue right into this major question that many people have. Should I have a will or should I have a revocable trust? And that is really a discussion of, should I have a plan that goes through the probate process, or should I have a plan that avoids the probate process? Now, first of all, we're going to talk about what the probate process is for wills, and we're going to talk about that, but I'm going to put out a big caveat here. To me, having done thousands of estate plans for clients, to me, it's not important whether you avoid probate or not. Now, this is a very personal thing for many of you, and many of you will want to avoid probate. There's no question that many of you will ultimately want to avoid probate. But to me, the most important thing is to get a plan in place. That is the most important thing, especially given the state of the world we're living in today. So I'm going to go through this analysis, but the most important thing is that you have a plan for what happens at your death, a plan for what happens for your incapacity planning. All right, so wills by their very nature are subject to the probate process. If we have no will, we are still subject potentially to the probate process. Now, why do I say potentially? Because we have to ask ourselves, what assets go through probate? A couple of simple examples, and I know many of you on this webinar are very educated people who already know this. So here's a quick question. Does a joint account, you have a joint account with a joint owner who has the right of survivorship, does that go through probate? And the answer is no. If you have an IRA and that IRA has a beneficiary, does that go through probate? The answer is no, because it has a beneficiary designation. But if I took that same IRA and said it has no beneficiary designation, does that IRA go through probate? And the answer is yes. That would be a very unfortunate thing. That IRA now has accelerated taxation and is going to go through the probate process when that was avoidable. So that's a problem. What if you are single or married and you have a piece of real estate, you have a residence or you have a rental property in your own name, you have a sole property in your own name with no beneficiary? Does that go through probate? And the answer is yes, that's going to go through probate because it's an asset that has no joint owner and no beneficiary. That's going to go through probate. So the probate process is very, very straightforward as I've outlined it here. It is a process that starts with opening the estate, and I'm giving you a very simple overview here. This is an oversimplification. The estate gets opened, there's an inventory, there are creditors potentially who could make claims, and they are limited to a certain period of time. There's an accounting or several accountings that are due depending on how long this process lasts. And in Maryland, typically, a probate process will be typically around 9 months. Probate in Virginia and other places has its own characteristics, but in Maryland, I think we could generally say that a probate process is about 9 months. The cost of probate is, according to AARP magazine, about 4% to 7%, depending on what state that you live in. So just recapping this, wills, or if a person has no will, they die intestate, that person will have probate if they have probate assets. And probate assets are assets that are owned in that person's sole name with no beneficiary and no joint owner. Probate does not necessarily cost 4% in Maryland, but those are the fees that are allowed by the court, generally speaking. It's about 4%. And that's the kind of thing I would think about if I was deciding versus a will versus a trust, which avoids probate. This is a will structure. So a good estate plan would have a will, powers of attorney, and advanced medical directive. Now, why? Why do we have these things? Well, if you look at the will is the driving force. The will is what happens at death. If you look at the powers of attorney and advanced directives, those things have to do with life. So we are planning for what happens at our death, what happens during our lives. So we want to make sure that we're planning for what happens at death, what happens in the event of incapacity. Now, some of you may have a revocable living trust, but I think, as Jeff said, many of you or most of you on this webinar have no estate plan. So if you're not familiar with this, a revocable trust is nothing more than an alternative to a will. So let's say you came to an estate planning law firm and you said, well, I want an estate plan. Well, the estate planner is going to ask you, well, let's take a look at the will, or let's look at an alternative to a will. So a will or a will substitute. So a revocable living trust is a will substitute. It's a private document that you can develop, and it has 2 steps. And by the way, wills have 2 steps as well. The implementation of the will and the beneficiary designations. Very, very important, especially in today's world. A revocable trust, which is an alternative to a will, has the same type of 2-step process as far as the major things. Getting the trust designed and getting it in place. But the second major step is to fund that trust, to take assets and move those non-retirement assets into the trust. So the way to think about this is your real estate, your stocks and bonds and mutual funds and cash and CDs, even savings bonds. And saving for those things and so forth would go into the trust as part of step 2, and now you would have a probate on those assets. Many of you have retirement plans. Those retirement plans do not go into a revocable trust. Those are separate and apart from the trust. So we have the retirement assets passing and life insurance passing with no probate because they have beneficiary designations. But we also have the assets that are in the trust passing with no probate because they are owned by the revocable trust. Remember, the revocable trust does not provide any kind of tax savings in and of itself. It doesn't provide any asset protection in and of itself. So these are myths that if we put assets into a revocable trust, that we have some kind of protection. And that's not true. This is simply an alternative to a will. It's a will substitute. Now, if we have done those 2 major steps, the design of the trust, the funding or asset alignment in the trust, if we've done that properly, now the cost of administration can be much lower than probate on a theoretical basis. And so this has to be maintained during your lifetime. And this is what a revocable trust actually looks like. Here we see the trust has replaced the will. See, we had a driving force of the will, but now the driving force is the revocable living trust. And we have the same powers of attorney, the same advanced medical directives. The revocable living trust is not better than the will. It's an alternative to the will. So someone who is looking at a will versus a trust, it's going to depend on your assets. It's going to depend on the nature of the assets. It's probably going to depend on your age. It's going to depend on your goals and values And that's why a will or a trust is not, one is not better than the other. We just have to evaluate the purposes of what we are trying to accomplish. Now, in addition to wills and trusts, I would say there's a third category. We have wills, we have trusts, but we also have this category, and I like to call this non-probate transfers or non-probate devices. So many of you are familiar with this already. Joint ownership, things that we have with our joint owners like spouses or partners or even children, even though joint ownership with children is not always a good idea for various reasons. Beneficiary designations, life estate deeds, transfer on death designations. Many financial advisors will advise their clients to have transfer on death designations. Those are sometimes advisable and sometimes they are not advisable, especially if you have a revocable trust that's there to control the assets. Payable on death designations. These are payable on death designations at a bank and so forth. So let's talk about this for just a second. We have wills, we have trusts, and we have these non-probate transfers. There's nothing wrong with these non-probate transfers. The problem that estate planners are going to have with these transfer devices is that there is ultimately no control for you, the person who is either the testator of a will or the grantor of a trust. The reason that most people do not use these transfer devices as the sole estate planning device is because there's a possibility, a big risk, that things may not happen in the order that we think they will. In other words, if one of the beneficiaries dies before you, depending on the nature of the assets, it may pass in a way that you are not anticipating. And the reason why the vast majority of people use wills and trusts is because they want to exercise control of the assets as they go down to the family beneficiaries and the generations to come. So with that said, these non-probate transfer devices can be very powerful under certain strategies. So we don't look at them in the estate planning world as actual estate planning an approach. We look at them as using these in coordination with wills and trusts and other strategies. But we do need to recognize that they do exist and they do have their place in the overall scheme of things. All right, Jeff, I've been talking for a little while. I'm just going to take a break here after about 30 minutes and see if we have any questions.
Well, thank you, Steve. Don't have any questions just yet.
Excellent, thank you. All right, so we thank you again for being with us and sticking through this dense material. So now we're going to go one step further from those non-probate transfers, and I'm going to illustrate one of the things that can happen in estate planning that we want to avoid. So here we have a will or a trust. It does not matter which one, but look at how the assets are owned. It's very important when you're starting to think about wills versus trusts and estate planning in general that we start to understand how assets are owned and how assets will transfer. So here in my hypothetical example, this person has put together a wonderful will or a wonderful trust, and they went to great lengths and great dedication to do that. But look at how the assets are owned. Assets are owned jointly, or they have a POD, payable on death beneficiary, or a transfer on death beneficiary, or a beneficiary designation. At the person's passing, look at how the assets are passing. They are not being controlled by the will or trust. Now that might be okay, but we need to understand and at least recognize that that is happening. It might be perfectly fine that this is happening, but if it's not, if we intended the will or trust to control these assets, this is not where we want to be, because now our document will not control the flow of the assets. Here's a good way of looking at this again. A person went out and created a wonderful estate plan, but look at how the assets are owned. So this is the point that's being driven home here, is that how assets are owned, or funding the assets into the estate plan, not just focusing on documents, but focusing on how the assets are owned and how they are being transferred. This is the most important thing. Arguably, how you own your assets at the time of your passing is arguably the most important thing in estate planning. So this concept, again, this masterclass concept, is that you just understand that titling of assets is critical and not just how the will or the trust says things are to pass. All right, so we're now going to plow ahead into a more an equally important, I should say, topic, which is understanding incapacity planning. I had a gentleman in my conference room just in the last 3 weeks that was over 100 years old. And I had a client who was also a gentleman who lived to 106 about 5 years ago. And we have many ladies who live over 100. And I always like to talk about how long people are living. And I know you know that. So even though we have a very uncertain world that we're living in, people are living longer than ever. So a good estate plan focuses not on just what happens at death, but also what happens during incapacity. So we have a very, unfortunately, high possibility of suffering an incapacity during our lives. And that's why we want to have what? A financial power of attorney in place, or as I have illustrated here, a set of 2 financial powers of attorney that work together. This is a certain approach that we have in estate planning today, but the most important thing is to have a financial power of attorney in place, an advanced medical directive in place so that you have someone who can act as your what? Agent, your healthcare agent, to make your decisions if you cannot make your decisions yourself. So powers of attorney and advanced medical directives are integral parts of estate planning today. And arguably, the power of attorney is the most important of all the estate planning documents because it provides for huge flexibility or moderate flexibility, depending on what your goals and desires are. But from a theoretical point of view, these documents, the powers of attorney, are the most important of all documents. And we can elaborate that on that another time. Now you'll notice that I've got the guardianship circle X'd out here because we definitely want to avoid guardianship. What is guardianship? Guardianship of an adult, not a guardianship of a minor, even though many of you may have minor children and you want to provide for guardians of those minor children. Here we're talking about avoiding guardianship of an adult, avoiding the possibility that if we are disabled and incapacitated during our lifetime, that we would have to have a guardianship proceeding, that we would lose our legal rights to our property, or that we would lose our legal rights to our person and basically become a ward of the court. Now, we don't want to do that. Guardianship is there for a very important reason. If there was no one to take care of us, if we had no agents, but here, powers of attorney are a substitute for guardianship. Advanced medical directive is a substitute for guardianship of the person. So these are tools. The underlying reasons for having them is not only that someone can take care of you, pay your bills, take care of your spouse and pay your spouse's bills, but also take care of any person who is dependent on you. Okay, very, very powerful. Okay, it's not only for those reasons, but it's for reasons for your own self-determination so that you can avoid guardianship of your person and property. Now you'll notice in my circle here, talking about powers of attorney, we have something called the Maryland statutory power of attorney. Now there are 2 major types of Maryland powers of attorney, and thank goodness we have these since 2010 because Maryland's power of attorney laws were very poor prior to 2010. Now we have a short form power of attorney and we have a broader limited form power of attorney. But the most important thing to remember here is that the Maryland powers of attorney are enforceable by law. That's a very big thing because at a time of crisis, do we want to have problems with the power of attorney? And the answer is absolutely not. I've seen that when I was a much younger lawyer in the days before 2010. We do not want to have problems at a time of incapacity. But we need to recognize that the Maryland forms are somewhat limited in the sense that they don't allow us to customize them. We are always looking to customize powers of attorney because we know in our practice, we know how powerful and how important those documents are. So we customize powers of attorney, and that's why I'm saying that in certain respects, the Maryland statutory form is not enough. I'm not going to go through every one of these slides. These are something for you to read to understand the enhanced powers that you can provide an agent. You are the principal. You are the person who is providing the powers to your agent. And believe it or not, you get to decide how much power they have. In a perfect world, we would want your agent to have as much power as possible in this perfect world. We would want your agent to be able to do the same things you could do yourself if you were able. But in the real world, sometimes we have to go over these powers and let you as a potential client see what those powers really are. And it's pretty shocking how much power that you can actually give today under a financial power of attorney. So ideally, you want to provide all these powers to your agent so that you have tremendous flexibility. But in a real world sense, sometimes those powers are a little bit scary and we may or may not provide those powers. So the flexibility issue is what we're talking about, depending on how much flexibility we want to provide. If we want to provide tremendous flexibility, then we are going to enhance our powers of attorney by using a general power of attorney in addition to a more limited power of attorney. So I'm not going to take you through every single one of these. These bullet points are designed to let you know the extent to which you can customize a power of attorney. All right, so hopefully I've driven home the idea that the financial power of attorney is very important. And just to illustrate that one more time, Jonathan Blotmacher, who's one of the world's most recognized estate planners from Manhattan, who's pretty much retired at this point, I think, he has declared before at certain conferences I have been at that the financial power of attorney is very, very important and the most important document in estate planning. All right, healthcare decisions. Now, having said that, for some clients, this is the most important of all documents. So what do I want you to know about the Maryland Advanced Medical Directive? I want you to know that you can customize it. I want you to know that this is the only thing that your agent will have in front of them to read at a time of crisis or at a time of a healthcare situation that will tell them what you want, that will tell them what your personal preferences are. Do you have custom provisions and desires that they should know about? Do you want to articulate these things? Well, you don't have to, of course, and most people don't, but I strongly recommend that you do because it is the only thing they will know that you want other than what you have told them verbally during your life. So the Advanced Medical Directive does what? It names your agents. It says when your agent's power is effective. It allows you to decide whether your agent has flexibility in their decision making or not. It allows you to articulate your end-of-life decisions in advance, make organ donation and pain medication choices, and final arrangements. Very, very important, very, very personal to you. Hopefully none of you on this webinar have ever had to deal with this, but Maryland has something called the Medical Order for Life-Sustaining Treatment. What is this? It's a medical order and it's required by law in Maryland. We don't have enough time today to go into this discussion. Jeff has some specific information about MOLST that he could send to you if you're interested, or you can go to the Attorney General's website. My advice as an elder law attorney is to make sure that you're somewhat familiar with MOLST. If you're over 65 years old, I think you should talk to your doctor or nurse practitioner about it, and to understand that it is required by law if we go into a facility, and to educate your healthcare agents about what it is. So MOLST is not something I want you to worry about. It's just something to know about and educate yourself and your family members about. All right, Jeff, it's 11:15. I think we are about 2/3 of the way through the presentation. I should be able to be done before 11:15. please interrupt me if there's any questions about anything we've talked about so far.
Thanks, Steve. We do have one question I want to go ahead and pass along to you here. And that question is, my father passed away last September, and I'm navigating the estate process now for the benefit of my mother. I feel like I need more guidance than I'm receiving from their law firm. Is it possible to move to Elville?
Well, thank you for that. And I'm very sorry to hear about your loss. The answer is yes. Any time that you are working with another law firm and you're not satisfied, remember and the matter is yours. It's not owned by the law firm, and that the file is yours, not owned. You could always move, and we talked to you about that, and I'm sorry that you're dealing with that. Thank you.
So Steve, if you could, you kind of
All
cut
right,
out a
so
little
now
bit
we're
there.
going to change gears here a little bit.
Steve, so you cut out just a little bit there in the middle
Thank
of
you,
your
Jeff.
response.
Thank you, Jeff.
Could you,
oh, could I repeat that? Yes, thank you.
yeah, you're cutting out just a little bit.
Can you hear me now, Jeff?
Repeat. I can hear you. If you
All
could
right,
just repeat part of your response there, yeah.
Thank you. So thank you, sir. I was just saying that I'm sorry for your loss and that you're having to deal with that situation. Yes, we would be glad to look at that particular case. Remember that when you're dealing with any law firm, and including that one that you're dealing with, the file is yours. The matter that they're handling for you is yours, and you can move that to any law firm if you're not satisfied with how things are going. So again, I apologize and for that, and sorry that you're dealing with that situation, and sorry for your loss.
Okay, thank you. And another couple of people asking about a copy of the MOLST information. I will be sending that out after the presentation. And a very brief note, if you're experiencing some choppiness with the connection, we have heard from our IT company that there is an issue throughout the country with Microsoft right now. So it is not just us here. You may be experiencing some issues at home as well. So we're certainly doing our very best, of course. So apologize for the inconvenience. And you can, I guess, call Bill Gates and complain. So, but we'll do our best here, and I think everything will be fine. Thanks.
Thank you, Jeff. I guess it's time to hit the boost button on the power.
That's right. Yeah, well, I'm going to do that.
And let me know if I start to cut out again.
Will do.
All right. So let's move on now to tax issues. We've talked about the fundamentals of estate planning, the reasons for planning, having goals for planning, understanding wills versus trusts, understanding the very, very basics. Excuse me. Excuse me, I'm being handed a message here. It must be about the technology. Jeff, I've just received an emergency message. I'm going to just step away for just a moment. I'll be right back. I apologize.
Thank you for everybody's patience. I'm sure Steve will be back momentarily. I've heard this presentation so many times, I think I could give it, but I'm not going to.
I apologize. So Jeff, I'm back. All right, and thank everyone. I don't think we've ever done that before, but I had to take an emergency call about a family member. I apologize. So the current tax environment is probably the best tax environment we have ever been in for estate planning. So let me describe that. For some of you on the webinar here this morning already know this information. And so we have a current tax environment where we have lower income tax brackets for most people. This is from the 2017 Trump Tax Act, where we have the highest income tax bracket as being 37% instead of 39.6%, although the Biden administration wants that to come back. But maybe more importantly, we have $12 million as our estate tax exemptions, $12,060,000 each. If you were not aware of this, you have an exemption of $12,060,000. I have a $12,060,000 exemption. And if you're married, the combination of those two exemptions, of course, is over 24 million. So we live in a world right now where these unprecedented exemption amounts exist. And for those who are very wealthy, there are lots of planning opportunities. If we are of moderate wealth or not a person of wealth, then there's not going to be any estate tax in your estate under this scenario. If you're a Maryland resident, Maryland has a $5 million estate tax exemption. So we have 12 million for federal, basically we have 5 million for Maryland. And we have portability. So I apologize about focusing on married people. If you're on this call and you're not married, I apologize. But for those who are married, we have something called portability, where the surviving spouse can port or use the exemption of the deceased spouse. So this is very advantageous in the world today of planning, and it simplifies the complications that used to exist around the idea of estate tax planning, where it had to be so complicated. So we're living in a world of unprecedented and happy tax environment. Now, with all of that said, the estate tax exemptions are due to be reduced in 2026. Last year, the Biden administration, in the Building Back plan, and Senator Sanders and Senator Van Hollen and many on the left and the various political spectrum, they wanted to see major reductions in the estate tax scheme, meaning not allowing so much exemption amount, and also changing things like eliminating the step up in basis and all of those things. If I die, my daughter, if I left her a piece of property, she gets the property at the new fair market value. That's the step up in basis. Well, that was going to be eliminated, but thankfully it was not eliminated. And a lot of those tax policy proposals came to a screeching halt around November of 2021. So we don't know what's going to happen in the future, but we do know in 2026, the federal government has slated that the exemption amounts will come down. So we will have to continue to wait and see on that. But that's one of the reasons why when you do estate planning, it's not just getting a set of documents in place, it's revisiting the planning as we go along over the years to come to keep up with changes in the laws. So that's one of the reasons for maintenance and updating. Now, in planning, again, if you're married, I apologize to the single people on the call here this morning. If you're married, you can exercise control over assets and leave assets into what is called a marital trust or other non-marital trust to control assets and how that goes down to your children, those and grandchildren and nieces and nephews. Those are still very viable options. We have those options to try to protect assets from new spouses, just to try to make some of you laugh on this call. A lot of people do get remarried, so as we get older, we have to think through that. And we have to understand new Maryland law, which we're going to talk about briefly, that actually addresses this issue about how much a spouse is entitled to and whether or not we have to have a prenuptial agreement if we want to make our planning work. So the tax environment and the legislative environment is always changing, and we always want to keep up with that as we go through the years to come. Now, many people will say, what is the difference between estate planning and elder care planning? What is elder law? What is this? Well, I think the biggest thing to understand here, just to get rid of all the myths surrounding this issue, is really just to understand that elder law or elder care planning is in many respects similar to regular estate planning, except it kind of goes in a different direction. It kind of diverges into asset preservation for long-term care, flexibility. As we get older, one of the most important things is flexibility in the planning, flexibility in trusts, flexibility in financial powers of attorney. In estate planning, we're not necessarily worried about divesting our assets, except some people of wealth would like to make gifts during life or make large gifts for estate planning, estate tax planning purposes. But in elder law, we're talking many times about divesting assets to try to give away assets to preserve those assets for Medicaid purposes, for nursing home purposes. And there are ways of doing that. And I like to say hitting several birds with one stone, so to speak. And as you think through having a very flexible platform of your planning and then engaging in certain strategies with flexibility to undo those strategies in the future if they have to be undone through Medicaid trusts and planning for veterans benefits and so forth. So this is one of the major reasons the difference between estate planning and elder law starts to go in a little bit of a different direction. Many people do conventional estate planning and then years later change their planning or merge their planning into a different plan as they're getting older, their needs change, and they have more elder care issues. Now, with that said, long-term care is really important, long-term care insurance. So if you have a financial advisor, we want to encourage you to have long-term care insurance or a hybrid product of long-term care or a hybrid product that's attached to a life insurance policy. We are not involved in that business, but we do work with many financial advisors along those lines. So we strongly recommend that you understand or start to get your mind around the difference between estate planning for pure estate planning purposes and the possibility of that plan evolving over time for elder care purposes. Now, as we begin to wrap up, I promised to talk about asset protection. So let's talk about asset protection in three different types of categories, because if we just throw out this broad term asset protection, we are going to be really talking about a very amorphous subject, very ambiguous, okay? Lifetime asset protection is one category. Many of you have a lot of lifetime asset protection, then you may not even realize it. Long-term care asset protection and asset protection at death. So lifetime asset protection starts with an understanding, and my apologies again to the single people on this call, for married people, owning property as tenants by the entireties, owning property as spouses, you have a certain basic level of asset protection in those assets. You even can preserve those tenants by the entireties benefits after you transfer assets into a trust. So in Maryland, you can actually own tenants by the entireties property in a revocable trust. Life insurance is protected from the claims of creditors if children are the beneficiaries or a spouse is the beneficiary in Maryland. Annuities are the same, asset protection. So many of you don't know that or did not know that, and you need to double check your beneficiary designations. You need to look at your, not just your real estate, but look at your non-real estate assets like a brokerage account and say, should I really be owning that as tenants by the entireties instead of joint tenants, where if we got sued, we could lose half of the assets. Now, qualified plans and IRAs. Qualified plans are protected from the claims of creditors because those are ERISA plans, they're qualified. IRAs are protected from the claims of creditors but inherited IRAs are not. The IRAs that we leave our children, grandchildren, or nieces or nephews, those IRAs are not protected. The Supreme Court ruled about 10 or 12 years ago, I think, that there's just no protection in those IRAs. They just took it away. So even though Maryland law says there is, on the federal level, there is no protection. So we have to assume if you're leaving IRA assets, and I know many of you are accumulating a lot of those, if you're leaving those assets to your individual beneficiaries, they have no asset protection in those IRAs. We have to leave those IRAs to a trust if we want to provide that kind of protection. There is something called a domestic asset protection trust. This is a creation of state law. Maryland does not have this because we are not an asset protection state, so to speak. What I'm talking about here is the ability to create a lifetime trust. We could create a lifetime trust in Delaware or in Nevada or Alaska or Wyoming or South Dakota and a few other states. And those states would allow us to say we have some basic asset protection during our life for assets that are non-retirement assets that we just dump into one of those trusts. Now that's a whole complex subject there, but this is appropriate for some people. In Maryland, we can create a marital trust during lifetime for those people who are married, and there are very, very good asset protection dynamics of that trust. And of course, at death, which we're going to talk about in a minute, we can provide asset protection. Now, asset protection or asset preservation in the long-term care context, we touched on this just a little bit. We can use a Medicaid trust as a powerful tool. A Medicaid asset protection trust is one of the most underutilized tools, I believe, in estate planning. And this is a trust that allows you to divest assets into this irrevocable trust, start the Medicaid period. We will call this the Medicaid look period, which is currently 60 months. Many people call this the Medicaid look back period. We like to call it the look forward period. This trust allows lots of advantages for income tax, asset protection, and a little bit of control for the person who has transferred the assets. A very powerful tool. We like to call this the Swiss Army knife of estate planning, along with life insurance. A veterans trust is a similar trust, but it's designed for someone who's divesting assets and also wants to eventually qualify for VA aid and attendance benefits, which is a tax-free income for veterans, certain veterans. Trusts established under wills. If we have a couple where one of the spouses is impaired, the issue here is, can we engage in some kind of strategy to preserve assets? And there are strategies, and those strategies have even been blessed now by Maryland law, that we can move assets to the well spouse's name and plan accordingly should that person die first, and we can protect assets in a big way for the surviving disabled spouse if that happens. I'm going to go down now to the 5-year look back period. We talked about this a little bit about Medicaid trust. If we have a pre-crisis, if we have an issue where we are concerned, but we can get ahead of that crisis by 5 years, that's where the Medicaid trust can really be a powerful tool. But in crisis planning, if that crisis has already occurred, it's very important to understand that in a spousal situation, that there are certain protections the government provides. If you are a spouse on this webinar and your loved one is disabled or has an impairment, you are not going to lose your house if you have the proper legal advice. So just know there's a lot of myths out there, a lot of ambiguities, but understand that if there is a crisis and you are married, there is a way to spend down assets in an advantageous way to preserve as much as possible for the well spouse. If you've done nothing else except do basic flexibility planning, powers of attorney, and advanced directives, in the event of a crisis, there is something called the rule of halves, where we can hopefully save, in most cases, up to 50% of the assets, even if there hasn't been a pre-divestment of assets in the 5 years preceding the crisis. Life estate deeds are a very simple way of doing some Medicaid planning. They are not always the best way, and they don't have a lot of flexibility. So we've talked about asset protection for life during lifetime. We've talked about asset protection in the long-term care context to try to set some of the stage for the different types of long-term care, the different types of asset protection planning. And lastly, I'm going to talk about asset protection at death. So not trying to be facetious, but this is the easiest way to provide asset protection is when we die. And it's very easy, in my opinion, relatively speaking, to protect the shares of surviving spouses. Protect them from what? Protect them from the claims of creditors, the claims of a new spouse, the claims of a bank in bankruptcy, to protect those spouses. To give assurance to the person who dies first that the assets will be going down to the family members eventually. Trust planning for children and grandchildren. We can provide for their protection, protection against mistakes, protection against doing silly things that young people do, protection if they have special needs, as we see at the bottom. Now, spendthrift protection means that a beneficiary cannot assign or give away their beneficial interest in a trust. So lots and lots of things to talk about in our conference room, talking about the design of these plans. Who are the trustees going to be? One of the biggest topics of discussion today. We talk about it at least several times a week with clients. The use of a special fiduciary called a trust protector to provide flexibility. Powers of appointment, what does that mean? What rights does the beneficiary have to give the assets to whoever they want, or only to certain individuals in the family, or none at all? These are all asset protection design issues. And of course, special needs trusts protect the assets for special needs beneficiaries. And we are very blessed to be doing a lot of special needs planning at Elville and Associates and working with those families. Now, as we start to really wrap up, we talked a little bit at the beginning about how important it was to have beneficiary designations to make sure that our plans aren't failing, our beneficiary designations aren't failing, because that's a disaster for taxes. But unfortunately, we are dealing with the Secure Act in any event. And I guess a couple of years now after the Secure Act was passed, most of you are familiar with this, I hope. And if you're not, I'll just tell you briefly. President Trump signed the Secure Act in December of 2019, and actually the Secure Act became law in January of 2020. This is going to affect most people. It's not going to affect you if you are saving for retirement. It's not going to affect you in the sense of what we're going to talk about today. It's not going to affect you and your spouse, most likely. But at your passing, it will affect your beneficiaries. So there are 5 exceptions to the Secure Act. All other people have to take the retirement assets in 10 years, meaning they have to pay tax, and those assets have to be distributed out of the IRA within 10 years. Many of you are familiar with this now. It ends what we used to call the stretch IRA. It means that we no longer have the luxury, except for these exceptions, and let's talk about what they are. Surviving spouses are exempt. People who are less than 10 years younger than the plan participant, this is a strange one, they are exempt. Minor children are exempt until they're age 21, and chronically ill people and disabled people, meaning people with special needs, and their special needs trusts are exempt. So those individuals can stretch out the IRA assets for their lifetime, but unfortunately, most people, the majority of people, will be subject, meaning children, nieces and nephews, grandchildren, will be subject to the 10-year rule. So all plans need to be reviewed. There are ways of dealing with the Secure Act, which is basically what? The Secure Act basically means the acceleration of income tax on retirement assets. There are certain strategies for dealing with it, and through your financial advisor and through your attorneys and CPAs, we would try to work on a potential strategy to deal with this. But otherwise, it's something that needs to be reviewed, it needs to be understood. And if we are fortunate enough to have the possibility of being one of those 5 exceptions for the IRA money, those individuals, we want to make sure that we don't have a problem with actually messing up the opportunity. So here's an example as we start to wrap up. Under the old law, there were 2 basic types of beneficiaries. A non-designated beneficiary, which meant the IRA asset had to be distributed in 5 years, or basically sometimes immediately and under those circumstances, and all taxation paid, or a designated beneficiary where the IRA assets could be stretched out for the longest possible time over the life expectancy of the individual beneficiary. Now we have 3 types of beneficiaries. We still have the non-designated beneficiary and the 5-year rule. We don't want that. We have the designated beneficiary, which is now the 10-year rule, and I'm oversimplifying the complex regulations. And we have the eligible designated beneficiary, which is the person who can stretch the IRA over their entire lifetime because they are exempt from the Secure Act. So all plans need to be reviewed, and the types of beneficiaries need to be reviewed and planned accordingly so we get the maximum stretch out that we can. Elville and Associates has a client care program. Jeff mentioned it. We are proud to be one of the only firms, I guess in less than 100 firms in the United States, that have gone through the client care program at the Client Care Academy. This is simply to provide the process that we talked about earlier to not only educate, but also to organize and provide a path forward for clients to learn and to get benefits from encouraging themselves and us encouraging them to keep their plans updated. And I'm not going to take you through every single one of these because you can read these yourself. We simply want to encourage people through our client care program, which is several educational events a year, including a social event and other benefits, so that people can have an opportunity to keep their plans updated and commit to that as we move forward. So I thank you for your time and attention today. Jeff, it looks like we are going to end just about 11:15. I encourage you to consult with us, of course. Come, let us show you how to have the time and to take the time to think, how to engage in a process. There is absolutely nothing to fear. It is a strange thing to come to someone you've never met with before and share very personal things, but we do have a process that allows you to complete an estate planning questionnaire. That's incredibly important. But remember, there's nothing to fear. Everything is confidential. We have state-of-the-art facility. We also can do virtual meetings. If you're concerned about coming in personally, in person, we want you to bring existing estate planning documents, although I don't think many people on this webinar have those. Here's an important thing. We want to encourage you to have a financial advisory team and a tax advisory team if you don't already have one. We want to be collaborative with your advisors. We want to be collaborative with your CPA or your financial advisor. And if you don't have one, we want to help you. If you don't have a team, we want to help you create a team. We want you to come with questions you may have. Feel free to take time to write down your questions and organize your thoughts. And if you don't, that's okay too. Again, we want to provide a path forward for you, a process for you. We want you to know we are here to help and be resources. We want to give you a place where you can take the time to think and develop your goals if you don't already know what those are. And we want to educate you and your family members. So that's an awful lot. I apologize about having to take a break during this webinar. I don't think we've ever done that before. Jeff, I'm going to turn it back to you, but I wish everyone a wonderful holiday weekend. Be safe and enjoy, and hopefully the weather will be much better. And thank you for your time and attention and spending your time today with us.
Well, thank you very much, Steve. Wonderful presentation as always. And so we do have a couple of questions here. And so for all the attendees out there, now would be your time to get those questions into Steve. You have a captive audience in Mr. Elville here, who's always very busy. So if you have those questions that you have in your mind you've been wanting to pose to somebody that knows what they're talking about, now would be your time to get those in, please. So we have a couple questions here that I'm going to actually wrap into one. We have somebody here that's in Virginia and is asking if the laws are the same in Virginia as they are in Maryland, and along those same lines, does Virginia have something similar to MOLST?
Thank you for that. That's a great question. The laws in Virginia are different than Maryland. I would have to double check. I have not heard that Virginia has MOLST, but a lot of states have what is called POLST. And that's just because Maryland had to call it something different. The provider or physician's order for life-sustaining treatment instead of the medical order for life-sustaining treatment. We are not barred in Virginia, but we do have clients in Virginia and we work with Virginia attorneys. But the laws for probate and other things are different in Virginia. And depending on where you live in Virginia, we'd be happy to help you and connect you and work with you.
Okay, thank you very much. So as we're waiting for the any final questions to come in, I have some follow-up to do for you as always. Try to send a substantive email out afterwards with some information, including the video from today. If you want to review it, share it with friends and family. I will send out some information about the MOLST, including our MOLST packet that we share with clients, some information about the Secure Act, also information about some upcoming events that we have. If you would like to see this event in person on June 10th, we're going to be at the Howard County Library East Columbia branch offering the similar presentation. So come out and join us in person. You can shake Mr. Elville's hand and mine, and we'll shake yours. That's going to be at 10 o'clock on Friday, June 10th. Also on June 15th, we're going to be welcoming back Kelly Nelson from Maryland Able, understanding Maryland Able accounts and how they benefit your loved one with special needs. Always a very popular presentation. So looking forward to welcoming Kelly back. And lastly, on June 22nd, what families need to know about planning for a loved one with special needs, and that's also going to be offered by Steve. So pretty busy June, and we'll look forward to seeing you on one of those webinars and in-person events. So, and looking forward to being in person at the Howard County branch, Howard County Library branch. So I'll see if we have any other questions. And it doesn't look like we do, Steve. So a little bit light on the questions today, which is certainly fine. And we encourage you to come and see us. Again, very wonderful place to come in and give you time to think. And I always like to emphasize the part about creating solutions for clients' needs here. That's what we do, and give a path forward for people. And that's something that, it's not just giving you a choice A or B, but really trying to dig in and answer questions and understand your needs, and then give you some options based on learning about your situation and giving you some solutions, which I think is really important and we do a great job at. So let us know how we can be a resource, and I'll be happy to be of service to you. So thank you for being part of our webinar today, and hope you have a wonderful and safe holiday weekend, and we will see you again soon on our Elville webinar series. Have a great day.